And another consideration, and I'll talk about further points to consider, would be life events, changes in life events. So what are those questions and considerations to determine whether you should update your estate plan? Well, you always want to think about what your goals are. What are my goals? Are my goals, is one of my goals to be having my beneficiaries and my family avoid the probate process? Am I going to be considering estate Medicaid planning? So those are a couple of considerations, a couple of questions you want to ask yourself. Like I said earlier, life changes, people change. Did you recently become married? Did you recently become divorced? Are you in the process of getting divorced? Are you in the process of getting married? That's an important thing to consider when updating your estate plan. Did you have any children? How old are your children? Did you have any grandchildren? How many children? How many grandchildren? What are their ages? As you have children or grandchildren or other people come into your lives and as they age, that's another consideration for whether you should update your estate plan. I'll go further into that in a little bit. Has a beneficiary of your estate plan become ill or become disabled? Are they applying for government means benefits? You want to make sure your estate plan is appropriately drafted so that those beneficiaries cannot be, their government benefits cannot be challenged. You don't want your beneficiaries to be at risk of losing their government benefits. Of course, when you have a will, you have an executor, right? When you have a trust, you have a trustee or you have multiple trustees. When you have your advance directives, you could have a power of attorney, an agent acting under your power of attorney, and a healthcare proxy, an agent acting under that healthcare proxy. Those fiduciaries, those people that you nominate under your estate planning documents, they may not be in your life anymore. You may not have the same relationship you once had with them, or they may not be otherwise able to act in those roles. You just want to make sure the players are appropriately updated. You can have an excellent plan that's drafted, but if you don't have those critical players who are able, ready, willing, and able to advocate on your behalf, your estate plan may fall apart or may not be distributed in the fashion that you wanted, and that defeats the very purpose of an estate plan. You want to determine the best way to distribute your property at your passing. Another consideration would be, are you more charitably motivated? Or did you used to be more charitably oriented and now not so much? You have specific individuals or specific companies you'd like to distribute your property to. That's another consideration. Has there been a significant increase or decrease in your assets? And this could be due to a change in jobs, due to you acquiring or starting a business or closing a business and winding down. So you want to consider your employment and your retirement. There are estate taxes that could be due, so you just want to consider how those assets can impact the possibility of estate taxes coming due. Depending on what state you're in, if there's federal, right, there's $11.58 million state tax exemption right now. If in New York, there's a $5.85 million state tax exemption. So if there's a significant increase in your assets due to employment, due to a significant inheritance, you just want to keep that in mind. Are you still living in the same state that you were living at the time you drafted your estate plan? You just want to make sure that all your ducks in a row, you have an estate plan that is appropriately drafted for the state that you're living in upon your passing. Taxes always change, right? There was the Secure Act that passed back in January of 2020. So that affected retirement plans. So you want to make sure that your retirement plans are appropriately updated. Your beneficiary designations may need to be updated. Your IRAs, your life insurance. You may need life insurance, or you may need to consider whether you have an appropriate amount of life insurance. Long-term care planning. You may need long-term care insurance. So just to dive a little bit deeper into those questions and considerations, I just want to take a step back and think about changes in your family, right? So if you are considering divorce, certainly divorce terminates certain estate rights, but if you're not fully divorced yet at the time of your passing, the spouse who you were hoping was not going to be your spouse may be inheriting under a will, or maybe a beneficiary of a trust you haven't had an opportunity to update. If you become married and you were in the process of getting married and you didn't have an opportunity to update your estate plan to swap out a specific person, that's something you want to consider in advance of any of those life-changing circumstances. If you are having a child or you already had a child and that child is young, you should be considering in your will nominating a guardian for that minor child. And as I mentioned earlier, those fiduciaries that you nominate in your estate plan documents, you want to make sure that they are updated. You may have selected somebody, a close friend or a sister or another sibling, to take care of your child who is a minor at your passing. But if your relationship changes with that person, you want to make sure that your child is looked after with the person you want that child to be looked after by. If you have a grandchild, if you have multiple grandchildren, you might want to consider whether you want that grandchild or those grandchildren to inherit and how they would inherit. You may want to consider education planning for them, setting up 529 plans. In addition, as your children age, you may want them to inherit a different way. So if they're a minor, you don't want everything going to them outright, right? You may set up a trust for them. As they get older, you may want them to just inherit outright, or you may want them to inherit as they age. And once they reach a certain age, you would want them to receive everything. What if they are already at that age, or you're thinking this child is ready to inherit fully? You may want to update your estate plan for that reason. Just thinking. Just going back to beneficiaries, children beneficiaries, you may also want to set up UJMA or UTMA accounts, Uniform Gifts to Minors Act or the Uniform Transfers to Minors Act. You may want to set up those accounts for them if they're still minors. You would need to consider evaluating beneficiaries and trustees, executors and personal representatives, and agents under any powers of attorney with respect to your children. If there has been a change in your family with respect to any illnesses or any disabilities, and they're applying for government means benefits, you may want them, or it may be better for them to inherit via a special needs trust. There are several different special needs trusts that are available. There could be special needs trusts set up with their own money. That's a first-party special needs trust, or you could have a special needs trust set up by someone else. That would be a third-party special needs trust. And depending on which trust it has, there may be specific provisions inserted into those trusts where there's Medicaid or government payback provisions. So you want to make sure that your estate planning documents are appropriately drafted to make sure that if it's a first-party trust, you don't want a child to inherit in a first-party trust. You want to set up a third-party trust for them. In a third-party trust, there is no Medicaid payback provision, whereas in a first-party trust, there is a Medicaid payback provision. So again, you just want to make sure that you're going over your estate plan and considering whether anybody is applying for government benefits and how they should appropriately inherit to not be forfeiting any government means benefits. Well, again, so just as relationships change, our estate planning documents really should change. It seems to be quite a bit of a hardship. It's certainly a process that not everybody is comfortable considering and working with, but making sure that your plan is in order. There's nothing better than that. Making sure that your beneficiaries, your families, those that you love, are appropriately taken care of. And if you want to avoid the probate process, you want to make sure that all of your ducks are in a row, as I mentioned before, having the appropriate documents drafted, making sure that your accounts, some accounts might have joint account holders and they can inherit those. They become the sole account owner. Making sure your retirement plans are updated, making sure the beneficiary designations are appropriately done to be in compliance with the Secure Act and any kind of changes in the law, which brings me to my next point. Laws change, and at times laws change with respect to estate planning. So how would you know if a law has changed that could affect your estate plan? Well, that's exactly the type of question you should be asking yourself, and you may want to speak to an attorney. You can give us a call and say, hey, has anything come about? There's an election coming. come January, depending on who is in office, you may want to consider what's going on with the tax laws and whether they affect your estate plan. As always, I'm certainly here to answer any questions. So as I continue, you're welcome to ask any questions in the chat box. Just taking a look to see if there's any questions. Okay. Sorry, just checking a look. So what is a third-party trust? Okay, so a special needs trust is a trust that is set up for the benefit of a person who would be applying or be in receipt of government means benefits. So a third-party trust would be set up for somebody with someone else's own money. So if you're planning for somebody that has been applying for government means benefits, you may not want your money that you want that beneficiary to be inheriting to go back to Medicaid. So you would set up a third-party trust, right? So it's third party, whereas a first party trust is set up with that beneficiary's own money. So first party meaning it's their own money, third party meaning it's someone else's money. Okay, what are components of an estate plan except will or special needs trust? So an estate plan can consist of many documents. It could be a will, it could be a trust, and there are many different trusts, like such as the special needs trust I talked about. It would include advanced directives. So that would be a power of attorney. There are several different documents for a power of attorney. There's a healthcare proxy, a HIPAA authorization form, which allows your agent acting under your healthcare proxy to access your medical records. There could be a nomination guardian. That would be the person you're not nominating to be the guardian of yourself. So not the guardian that you're nominating for your minor child, the guardian for yourself. So should you become incapacitated, you yourself, you would nominate someone to become your personal needs guardian or your property affairs guardian. Personal needs guardian means someone who makes sure you go to your doctor's appointments, make sure that you're eating your food and getting your food. Property management guardian, someone who's managing your affairs, stepping into the shoes of yourself and making sure that bills are getting paid, making sure taxes are getting paid. Okay. And there's also a document that we call the appointment of an agent to control the disposition of your remains. So this is someone you can appoint to take care of your affairs upon your passing. Should you wish to be cremated, should you wish to have a funeral, this person would be making sure that those wishes are followed through. Okay. Okay, third party equals special needs. Okay, so right, so third party trust is a special, sometimes it's called a supplemental needs trust or a special needs trust. But if it's a third party trust, it may not say that in the title, but if it's a third party trust, it is a special third party special needs trust or third party supplemental needs trust. Okay. In this era of Zoom, do trustees, executors, etc. need to reside in the US? Well, they may not necessarily need to reside in the US, but they do need to be citizens of the United States. Okay. Just going through the chat to see if there's any private messages. Yes, will you send this recording to us to review the information? Yes, this presentation is being recorded, so certainly you're welcome to send us any questions you may have, but this will be recorded and we will be sending it to everybody to access. right, so again, just to recap, should I update my estate plan? Perhaps, it depends, but ultimately, yes. Just the timing would be appropriate to consider. So again, life-changing moments. What are your goals? If your goals change, if your relationships change, if your number of dependents change, has your child grown older? Do you find that your child is far more responsible than your child was, when you first drafted your estate plan? Are you married? Are you divorced? Are you considering getting married or getting divorced? Those are certainly things that you want to consider. And if you are considering either of those things, you would want to consider updating your estate plan just to make sure that your affairs are in order prior to the happening of either of those events, or perhaps even after, just to make sure that everything is established. Okay, and again, as I was mentioning before, since your relationships do change, you just want to make sure that your nominated fiduciaries are the appropriate choice for you at the time of your estate plan and as you grow older and as your relationships grow older. If you want to update the individuals who you nominate as your executor or trustee or agent acting under your power of attorney, you want to make sure you do that as quickly as possible. Does the attorney matter who updates? Certainly, if you have a relationship with the attorney who drafted your estate plan, you can certainly always go back to that attorney. They know you. You can go to that attorney and say, hey, this happened in my life. Do I need to update my estate plan? Should I? When should I do it? And then an attorney can certainly appropriately guide you. You can always go to another attorney and say, hey, I had this done. This has since happened in my life. Here's a copy of my documents. And you can work with that new attorney to appropriately bring your estate plan up to date. Just going through the chat. Okay. Certainly, if anybody has any questions, you're welcome to ask them right now. You can always reach out to us again, and someone can get back to you with a response to your question, or you're always welcome to reach out to us and we can schedule a consultation if this presentation sort of inspired you to think about your circumstances and whether it's appropriate for you to start thinking about updating your estate plan. We're always here. You can always go to littmankrooks.com. We are always available here for you. Certainly, this information is posted online. And again, this presentation is being recorded, so if you'd just like to re-jog your memory of anything that I mentioned earlier, you can certainly do so. I would like to thank everybody very much for their time. It's been a pleasure. I hope you will join us next week for a lunch with Littman Krooks. Oh. Suggestions on leaving, just before we go, I'm sorry, there's one last question. Suggestions on leaving passwords and private information for executor. There is, what we do at Littman Krooks is we create an estate planning binder for you. And this is what houses all of your original documents. And we will include letters of last instruction. And this is something you can provide for your executor or any of your agents, that they know where all of your information is, they know what accounts you have, and you can provide your passwords for them, and also private information. That way they have it all handy with your documents on a separate document that shows them exactly where to find everything. And on that note, we do have for next week responsibilities of an executor for next week's Zoom conference, so I do hope you'll all join us next week. That will certainly go into further about the responsibilities of an executor, and we'll tell you exactly how that executor will know what to do. All right, so thank you, everybody. I hope you all have a lovely day, and join us again next week. Thank you.